This tutorial looks at the basic elements of a court opinion published in the Supreme Court Reporter, which is the reporter of U.S. Supreme Court decisions published by West. It's available in print on the fourth floor of the library and online through Westlaw. We're going to look at Texas v. Johnson, which is a case from 1989 in which the Supreme Court held that burning the American flag is protected speech under the First Amendment. This is the first page of the opinion in the Supreme Court Reporter. There are several features to note. First, the citation. The citation is the reference to the place where the case has been published. We see 3 citations to the case on this page, referring to 3 reporters in which the case has been published. At the top of the page, we see the Supreme Court Reporter citation. This indicates that the case is published in volume 109 of the Supreme Court Reporter set, starting at page 2533. And indeed, here we are at page 2533, and here's the case. Above the case name, we see 2 parallel citations. Often, the opinions of a given court are published in more than one source. In that situation, multiple citations may be given. These additional citations are known as parallel citations. In Table 1 at the back of the Blue Book, you can find the abbreviations for the various reporters. Here, U.S. stands for United States Reports, the official Supreme Court reporter published by the Government Printing Office. So, in the United States Reports, you can find this case in volume 491, starting at page 397. LED is the abbreviation for United States Supreme Court Reports, Lawyers Edition, which is the Supreme Court Reporter published by Lexis. This citation indicates that this case is found in volume 105 of the second series of that reporter, starting at page 342. Below the parallel citations, we have the caption. The caption includes the names of parties in the case. Generally, the first party is the plaintiff and the second party is the defendant. Note that as cases are appealed, these parties may reverse position. Here the caption indicates that Texas is the petitioner, indicating that it's the party that lost in the prior proceeding. The docket number below is the number assigned by the court to track a case through the litigation process and keep track of documents related to the case. Note that new docket numbers are assigned at each level. Below the docket number, we see the date on which the case was argued before the Supreme Court and the date on which the opinion was issued. Below that is the beginning of the summary of the opinion, which was written by West's editors. It continues on the next page. This summary is not part of the official opinion. It describes which justice wrote the majority opinion, what the holding was, and whether any concurring or dissenting opinions were written. The headnotes are printed below the summary. West publishes these headnotes with key numbers to summarize the points of law raised in the case. Other publishers, such as LexisNexis, also usually include a similar feature. Because headnotes are written by the publisher and not by the court, you should never rely solely on them, and you should cite only to the actual text of the opinion. Headnotes are very helpful, however, in finding other cases that discuss the same point of law. In the West system, you could use the topic and key number assigned to the headnote to find other cases that discuss the same point of law. The syllabus, a longer summary of the case, follows the headnotes. Like the headnotes, it is not part of the official opinion. It was written by the Reporter of Decisions of the Supreme Court, who is the official charged with editing and publishing the court's opinions. Here, the actual opinion doesn't begin until page 2536 of the Reporter, where Justice Brennan's majority opinion begins. This is the opinion that sets forth the decision of the case. A concurring opinion is written by one or more judges or justices who agree with the disposition of the case, but for different reasons than those relied upon by the majority. When no absolute majority of the court can agree on the basis for deciding the case, The decision of the court may be contained in a number of concurring opinions, and the concurring opinion joined by the greatest number of judges is referred to as the plurality opinion. You can cite the concurring opinion as persuasive argument, but you must indicate in your citation that you are citing the concurring opinion, not the majority opinion. The dissenting opinion, written by Chief Justice Rehnquist and joined by Justices White and O'Connor, begins on the next page. A dissenting opinion, or dissent, is written by one or more judges expressing disagreement with the majority opinion of the court. Like the concurring opinion, you can also cite the dissent as persuasive authority. And those are the basic elements of a case. Remember, you can always ask a reference librarian if you have any questions.